Okay, let's unpack this. We're diving into GR L-47745 today. That's the Amadora versus Court of Appeals case. And for you listening, this isn't just some dry legal ruling. It's really the moment the Supreme Court had to, well, basically rethink the whole idea who's responsible when something terrible happens at school involving a student.
Absolutely. It's a landmark case, really, because of the legal tension it highlights. The court used this incredibly tragic situation to redefine school responsibility. But then, and this is the twist, the actual school involved ended up being cleared.
Yeah, it's kind of baffling at first glance. How does that even happen?
Exactly. We need to figure out how both those things can be true at the same time.
And the stakes, well, they couldn't be higher. This whole case revolves around the death of Alfredo Amadora back in 1972. He was just 17, a high school student. He was shot by a classmate, Pablito Daffon, fatally shot. And it happened inside the school auditorium at the Colegio de San Jose-Recoletos, just, 3 days before he was supposed to graduate?
Just heartbreaking. And Daffon, the shooter, he was convicted of homicide. But the Amador family, understandably, also went the civil route. They sued the school itself, the rector, the principal, the dean of boys, even a specific teacher, all under Article 2180 of the Civil Code.
Right. So our mission here in this deep dive is to really trace the court's path. We need to look at the old legal interpretations they had to kind of push aside, how they ended up broadening the liability for pretty much every school, and then the big question, why, even with that wider net, this specific school and its officials were ultimately absolved.
Yeah, it really forces you to appreciate the gap sometimes between, setting a legal principle and then applying that law to a very specific, very messy set of facts.
Okay, so let's get right into it. The heart of the confusion for decades was this one part of Article 2180. The key bit says, lastly, teachers or heads of establishments of arts and trades shall be liable for damages caused by their pupils and students or apprentices so long as they remain in their custody.
Such a short sentence, but wow, it packed in two huge ambiguities that courts just wrestled with for like 50 years before Amador finally tackled them head on.
So the first big fight was over custody. What did that even mean? The Amadora family argued, look, our son was on campus doing something required for graduation, a physics experiment, a report, something like that. He was there for a legitimate school reason. Clearly, he's under school custody.
Makes sense. But the school, they pushed back hard. They said, well, the semester's officially over. Classes were in session. So their argument was, our formal custody ends when the semester ends. Therefore, we can't be responsible for what happened inside the auditorium after that point.
Okay, that's one problem. And the other, maybe even bigger issue was that phrase, establishments of arts and trades.
Yeah.
Colegio de San Jose-Recoletos. It's an academic school, right? Like a regular high school or college. So did this law about arts and trade schools even apply to them?
And that's where the history gets really tangled. If you look back at the older cases like Ex Conde and Mercado, well, they really muddied the waters. Those rulings seem to suggest that academic schools were not covered, that they just didn't fit the arts and trades description in the law.
Didn't Mercado also have a really weird take on custody? Something about living with the teacher.
Oh, yeah. That was quite something. Mercado actually suggested that for a student to be in custody, they had to literally live and board with the teacher.
Oh.
I mean, imagine applying that to a modern school. It made the rule almost impossible to use for day schools.
And completely impractical.
Thankfully, that specific interpretation got thrown out later. In the Palasoc v. Briantes case in 1971, Palasoc said, no, custody exists for supervision purposes as long as the student is actually at school, even during recess.
Okay, so Palasoc helped on the custody front. But didn't Palasoc involve a technical school?
Exactly. That's the catch. Palasoc was about the Manila Technical Institute, arguably an establishment of arts and trades. So it fixed one part of the confusion, but it left the big question hanging. Does Article 2180 apply to purely academic schools? Nobody knew for sure.
Right. So the legal landscape was just a mess.
Total confusion. And that's precisely why the Supreme Court in Amadora knew they couldn't just tweak things. They basically had to rebuild the understanding of this article from the ground up.
Okay, this is where it gets fascinating. How did the court stretch a law seemingly written for vocational schools to cover all schools, academic ones included, without, rewriting the law itself?
They essentially said that the distinction wasn't logical in terms of responsibility. They ruled that Article 2180 applies to all schools, period. Academic, vocational, technical doesn't matter. They reasoned there was no good basis, legally or logically, to say academic schools should have a lower standard of care or supervision than vocational ones. Doing so would just be arbitrary.
But they still had the text scaring them in the face. teachers or heads of establishments of arts and trades. How did they handle that specific wording?
Ah, that's where they used a clever legal tool, a canon of construction called redendo singula singulis.
Okay, English, please.
Ha, right. Basically, it means referring each to each. They looked at the list in the law. You have two types of people, teachers, heads, and two types of institutions implicitly mentioned, academic, arts, trades. They decided the law intended to pair them up specifically.
Wait, so they read it as teachers are liable in academic schools and heads are liable in arts and trade schools. Is that it?
That's precisely it. It's like drawing lines connecting the right pairs in the list. So liability depends on the school type. For academic schools, the teacher in charge is the one potentially liable. For arts and trade schools, the head of the establishment is potentially liable.
That seems kind of old-fashioned, that distinction. Why hold the head of a technical school responsible but only a specific teacher in an academic one? Doesn't the head of an academic school also have overall responsibility?
The court actually acknowledged that. They said the distinction comes from history. Think way back, master and apprentice, that's the origin of arts and trade schools. In that old system, the head was like a master with really direct, close, almost parental supervision. But the head of a big modern academic school, their role is mostly administrative, managing the whole institution. They don't have that same minute-to-minute oversight of every student. So the court reasoned, in an academic setting, the liability has to fall on the person who does have that direct supervision the teacher assigned to that student or class. They even admitted this historical basis is pretty outdated now, but said, look, we have to interpret the law as it's currently written. If the legislature wants to change it, they can.
Got it. Sticking to the text, even if it feels archaic. Now, what about the other big piece custody? Did Alfredo Amadora being on campus after the semester ended still count?
Yes, absolutely. The court really broadened the definition here. They ruled that in custody is not strictly tied to the academic calendar, not just the first and last day of classes. A student is considered in the school's custody as long as they are on the school premises pursuing any, and this is the key phrase, legitimate student objective.
So submitting that physics report counted, even maybe just being on campus to use the library or attend a club meeting after hours.
That's the implication. Anything legitimately related to being a student there. The court framed custody less about immediate physical control and more about the school's ongoing influence and discipline over the student while they're engaged in school-related activities on campus.
Okay, that's a huge expansion of responsibility for schools, a really significant shift.
Definitely. It was a major clarification that, in principle, made it easier for future plaintiffs to argue a student was under school care.
All right, so here we are at the core puzzle. You've laid out two big points from Amadora. One, the liability rule applies to all schools now, academic included. Two, Alfredo Amadora was considered to be in the school's custody when he was shot. So, if the court widened the net for school liability so much, why did the Amadora family ultimately lose their case? Why were the school and its officials let off the hook?
It boils down to how that liability rule gets applied specifically in academic schools. Remember the distinction. In academic institutions, liability falls only on the specific teacher in charge.
Not just any teacher or the administration generally.
Correct. And the problem for the Amadora family was proving that the designated teacher in charge of the student who did the shooting, Pablito Daffon, was negligent. Or proving that any specific person who could be held liable under the rule failed to exercise the required diligence.
So let's break that down. The rector, the principal, the dean of boys, they were sued. Why were they cleared?
Because their authority was general, administrative. They weren't the designated teacher in charge exercising direct supervision over Daffon or the specific situation. Article 2180, as interpreted for academic schools, demands that specific link.
Okay, so the focus shifts to the teacher. They sued Celestino Daikon, the physics teacher, right? Since Alfredo was there for a physics requirement, what happened there?
Two main problems for the plaintiffs. First, they couldn't definitively prove Daikon was the designated teacher in charge of Daffon, the student who committed the act. But maybe more importantly, even if he was, there was simply no evidence presented to show Daikon himself was negligent. Was he lax in discipline? Did he fail in his supervision? There was no proof of that.
So just because he wasn't physically present at that exact moment in the auditorium doesn't automatically mean he was negligent.
Right. The court said his absence wasn't negligence per se. You'd need to show a pattern of laxity or a specific failure in supervision that contributed to the incident. They didn't have that evidence.
So the case against the specific teacher didn't hold up. But wait, there was that other incident you mentioned earlier involving the dean of boys, Sergio Damaso Jr., and a gun. Didn't the family argue that was negligence?
Yes, that was a really crucial point in their argument. Damaso, the dean of boys, had earlier confiscated an unlicensed pistol from a different student, Jose Gumban. But instead of reporting it or turning it over to the authorities, he actually just gave it back to Gumban later.
Okay, that sounds negligent. Returning an unlicensed weapon to a student seems like a failure to act responsibly, like not observing the diligence of a good father of a family, as the law puts it.
The court actually agreed. They explicitly called Damaso's action clearly negligence and said he deserves sanctions for it. Big admission there.
So why didn't that stick?
Proximate cause. That's the legal hurdle. The family couldn't prove that the specific gun Damaso negligently returned to Gumban was the same gun that Pablito Daffon later used to shoot Alfredo Amadora. The identity of the fatal weapon wasn't established in court. So while Damaso was negligent in that earlier separate incident, they couldn't legally connect that specific negligence directly to Amadora's death. The chain of causation was broken.
Wow. So a clear act of negligence by a school official, but no way to legally tie it to the tragic outcome.
Exactly. It shows how specific the requirements of proof can be in these cases.
So summing up the absolution, the administrators weren't the teacher in charge, the actual teacher wasn't proven negligent, and the dean's separate negligence couldn't be linked directly to the harm.
That's the gist. And underlying all of this is the defense available under Article 2180 itself. Even if liability seems to attach, it's not automatic. The teacher, or the head in an arts and trade school, can always escape liability by proving they exercised all the diligence of a good father of a family, that bonus paterfamilias standard to prevent the damage from happening. The school itself can also raise this defense against vicarious liability.
Right. The due diligence defense. Always important. Okay, let's zoom out a bit from the specific facts. The Amadora ruling also brought into sharp focus a really interesting, maybe even strange point about student age and teacher liability.
Oh yeah, this is a huge takeaway and kind of counterintuitive, like you said. The law, as interpreted, holds teachers potentially liable for the torts, the wrongful acts causing harm of their students, regardless of the student's age, as long as they're in custody.
Regardless of age. So even if the student is 18, 19, legally an adult.
That's the implication. Now contrast that with parents. Parents' vicarious liability for their children's torts generally ends when the child reaches the age of majority.
Wait, seriously. So the law is actually tougher on the teacher than the parent in that respect. A parent isn't liable for their 19-year-old's actions, but a teacher could be if that 19-year-old student does something wrong while under school custody.
That's exactly the distinction the law creates. It's quite striking. The court kind of acknowledged the logic seems backwards, you'd think. The connection to the parent lasts longer. But the text of Article 2180 doesn't mention an age limit for students when it talks about teacher liability. So this potentially long-lasting responsibility falls on the teacher, even for adult students.
That just feels awkward,
Yeah.
legally awkward. And apparently some of the justices thought so too. There were concurring and dissenting opinions that really questioned this whole setup, right?
Absolutely. Justice Gutierrez Jr., in his concurring opinion, was particularly blunt. He called Article 2180 basically a relic of the past.
Strong words. What was his reasoning?
He argued that the whole idea of in loco parentis, the school acting in place of the parent, just doesn't fit modern times, especially with older students, like in college. He pointed out that many university students today would actively resist the idea that the school has parental-style authority over them, and the old master-apprentice model. Completely gone. He basically suggested the law was outdated and causing mischief and injustice. He thought maybe it should be amended or even scrapped, just letting regular negligence rules apply instead of this special vicarious liability for teachers.
That's a compelling point. If a student is legally an adult, making their own choices, why should their teacher be held responsible if they commit a tort?
It's a very fair question. But then you had Justice Melencio Herrera, who dissented, arguing the other way, sort of. She thought the majority opinion was actually too narrow in defining the teacher in charge.
Too narrow. How so?
She believed the liability shouldn't just be pinned on one specific designated supervisor. She argued it should extend to any teacher or professor who exercises that substitute parental authority, the in loco parentis role, while the student is effectively under the school's care. Her view was more about the general protective duty of the school and its staff, substituting for the parents more broadly whenever the student is on campus.
So different justices pulling in completely opposite directions about how this old law should apply today.
Exactly. It really highlights the tension inherent in the ruling.
Okay, this deep dive has really shown the knots the Supreme Court had to untangle. Decades of confusing precedent, a really tragic event, and a law written for a different era. So, for you listening, what are the absolute key takeaways from Amadora?
I think there are two huge ones. First, Article 2180 liability isn't just for vocational schools anymore. It applies to all educational institutions, academic included. That's a major expansion. Second, the definition of custody got much broader. It's not just class time. It covers students on campus for any legitimate school purpose, even outside the formal semester.
So the potential legal exposure for schools definitely increased because of Amadora. But, and this is the paradox we started with, we also saw how the specific application, especially the need to pinpoint the negligent teacher in charge in academic schools, could still lead to absolution. The Amadora family couldn't meet that specific burden of proof against any one person, despite the wider principles being established.
Right. The court essentially said, we're applying the law as it's written, warts and all. They acknowledged it might not be perfect for today's world, especially with older students, but changing the law itself. That's the legislature's job, not the court's.
And that leaves us with a really interesting thought to chew on. The court applies the law, it doesn't write it. So think about this. We have students getting older, often reaching legal adulthood while still under school supervision. We have this legal quirk where parents might be off the hook for their adult children's actions, but teachers potentially aren't. How should modern law balance that? Balance the need for safety and accountability in schools with the reality that teachers' actual authority over older near-adult or adult students is, well, diminishing and sometimes even resisted.
That's the million-dollar question, isn't it? It pits this historical idea of school protection against the modern reality of student autonomy. Where that balance should lie today, well, that's something that legal systems are probably still figuring out.
Definitely something to keep thinking about. Thank you for joining us for this deep dive. We'll see you next time.